Mr. Sewell.
May it please the court, I appear with Mr. Archer for the appellants. Mr. Cloherty, King's Counsel, with Mr. Fenimore, appears for the respondent. This is the hearing of an appeal from an order in judgment of Mr. Justice Jacobs, sitting in the Commercial Court following a trial that took place in 2024, judgment handed down on 28th of March 2025. Now,
let me just do some housekeeping. We've obviously read the materials. I'm aware that you very helpfully produced us a timetable, which we would now like to upset. Having read into the case, our feeling at the moment is that it's going to be easier for us to grapple with the arguments if we hear both of you on grounds 1 and 2 first, and then both of you on the other matters later. Now, I know that doesn't fit in with your timetable, but I'm hopeful that you can adapt to that.
We'll certainly do whatever it requires, I'm sure. We'll proceed on that basis.
Yes, please.
Other housekeeping matters, if I may. First, the court should have a core bundle comprising 2 volumes, using hard copies, which it appears the court is. A supplemental bundle comprising 1 file, an unagreed bundle comprising 1 further file, a slim file containing the appellant's supplemental skeleton argument for which permission was granted, thank you for that, my lord, and an authorities bundle originally comprising 4 volumes, now with an additional volume which includes some additional materials from the parties, as well as the additional case and article to which my Lord Justice Newey referred the parties yesterday. I also have brought to court, should we feel the need to call on it, the very recent Supreme Court decision in the Saxon Woods case, which considers the nature of the Section 1721 duty on a director, the extent to which it's subjective or objective, and so on. I won't hand that up now. I'm sorry.
I was just going to ask, I think I have my authorities differently arranged, particularly as the files all break. But please would you tell me what the last tab is? Because I don't have a 5th volume, I have 2 4th volumes.
I see.
So my last tab is 48.
My last tab is 54.
Oh, well, I'm missing some things then.
I don't think I've yet been in an appeal where there hasn't been some issue with the bundles of that nature. I was once told by my Lord Justice Phillips that he had no tabs in any of his bundles at all. So
that's
maybe,
quite common, I think.
That's yeah.
my lady, I'm sorry.
No.
And we will. Can I suggest that at the earliest opportunity we have an opportunity to check what you have and what you don't have, and make up the deficit.
That's very kind, thank you. And I'm sure we won't come to authorities between 48 and 54 too soon.
Hopefully.
I stop at 52.
Very well.
But speaking for myself, I'd rather you didn't crawl all over my bundles, which are marked up, but
Of
just
course.
provide me with tabs 53
The missing
and
tabs.
54.
No, certainly. We'll do the same for my lady.
Actually, I stop at 52 as well. I don't know what 53 and 54 are. The only other...
I think they may be the materials that my lord referred us to yesterday. But
They seem to be 51 and 52.
oh, I see. No, in that case, there are 2 additional authorities from my learned friend which have come in overnight.
The other thing is, with Grenby Valley, I'm not aware of that being supplied in hard copy. Were it supplied in hard copy, I think I'd put it in file 5, because file, whichever it is, 3 or 4, is already very full.
I think I did have that.
Very well. So Grenby Valley, and then the missing tabs, which I'm sure those sitting in court have got a good note of in respect of every member of the Constitution, and we'll get those gaps filled as soon as we can.
Thank you very much.
I was going to address you on the timetable, but we've dealt with that. My lords, if I address you as... Is it permissible, my lady, if I address the Constitution collectively as my lords? If that's not acceptable to you, my lady, I won't do that, and I will just not use that form of word.
I think it will irritate me quite a lot.
Very well. I'm glad I asked. I just won't use that form of words at all. Now, I don't propose to spend, unless the court wishes me to do so, any time on the application for the unagreed bundle. We are content between us for the court to consider those matters de bene esse and to wrap the matter up in the judgment. We've both set out our positions in writing. the short point is, from our side, it's a limited selection of materials. We've referred to them all individually in the skeleton. I may refer to some orally. It's not an example of incorporating the trial bundle by reference, see trial bundle, and then putting the whole trial bundle before the court. It's much more selective than that, and it's about 200 pages of material in total. Now, moving on, the appeal in outline. You have the procedural history of the appeal, my lords, my ladies, paragraph 6 of the replacement skeleton. And we have been granted permission by Lord Justice Popplewell on several grounds, and you'll be familiar with them, but just by way of reminder. First, the question of the scope or content of the fiduciary duty owed by XY to the appellants. That's referred to as ground 1. Secondly, the question of whether the appellants gave informed consent to what XY did, and that is ground 2. And then 3 and 4 relate to the impact of the prior findings of the court on 1 and 3. So 3 is the claim for an account of profits, as well as the arguments in respect of XY's fees. That was originally ground 4 in the application for permission to appeal, but it remains described as ground 4 in the skeletons. There's no ground 3 because my Lord Justice Popplewell refused permission on the dishonest assistance issue. And then the 4th ground, numbered 5 in the documents, is causation and loss. Now, there is also a further issue which is raised by way of respondents' notice and addressed in the skeletons, including our supplemental, which is the question of whether the terms and conditions of XY bar recovery. Now,
That's clause 3G.
It is. I'm going to address you first, if I may, in the context of ground 1 and 2 on the factual background. Now, I genuinely appreciate the court will be anxious to get to and grapple with the legal principles. But if I may respectfully adopt what the late Edmund King said shortly before he died, every case ends up being decided on its facts, even sometimes the ones that aren't supposed to be decided on their facts. And so if I may, I will address you on that. If I'm taking too long, let me know and I will accelerate through the process. And the purpose of this factual summary, my lords, my lady, is obviously to set the scene for the discussion on grounds 1 and 2. Now, I'm going to start with the core history of the relationship between XY as financial advisor and my client's investments in the relevant compartments of the Skew Base Fund, and what the judge found XY told my clients, did tell my clients, did disclose about the fund. And clearly what follows is not an attempt to summarise the entire judgment. That would be impossible in the time available. And I will refer you, if I may, to certain paragraphs in the judgment. It's not so that we turn them all up, time wouldn't allow, but it's so that you have the references for the future. Now, as you will be aware, the appellants engaged XY from mid and late 2016 onwards to provide them with financial advice, as the judge found. Now, the start of the relationship between the parties, perhaps I could explain who the parties are first. GI Globinvestment Limited, the first appellant, is an English company used by the de Montezemolo family to make and hold investments, effectively as part of the family office. And then we have Mr. Matteo Cordero de Montezemolo, who is a member of the family, and I'll refer to him as MDM, as the judge did, and the parties have in their documents. Now, XY ERS Limited is an English company, which was at the time, but is no longer authorised to carry out regulated activities by the FCA, and it was founded by and is owned by its CEO, Mr. Daniele Megani. My clients were introduced to XY in mid-2016 through a mutual acquaintance, and how XY presented itself to my clients at the point when the relationship was initiated frames the relationship and was relied upon by the judge as one of the factors giving rise to the fiduciary relationship. And the judge refers to this, my lords, my lady, paragraphs 190 to 196 of the judgment. And you will see, if we can turn this up, in Core Bundle Volume 1, Tab 5, Core Bundle Volume 1, Tab 5. And it's paragraph 190, which is at page 106. You will see the judge quotes the home page reproduces effectively the text of the homepage of XY on its website at the material time, which the judge found Mr. Nutso, who later became a director of GIG, read. And you will see the references on the homepage to XY providing unbiased consultancy, free from conflict of interest, in the first paragraph at the end. In the second paragraph, you will see in the second sentence a reference to it being a neutral partner to the shareholders of large-scale treasuries. Overleaf, at the top of page 107, you will see the reference to vendor independent. And I should add that unbiased consultancy and vendor independent were emphasised or highlighted in the website as it appeared online. And you'll see the final paragraph about XY being committed to transparency and independence in all aspects of its work. Now, as I mentioned, the judge found that Mr. Nutso, who worked for the family and became a director of GIG, was entitled to understand and did understand at the time that this was the manner in which XY conducted his business. Now, there were then meetings between the parties in 2016. Those meetings were generally attended on XY's side by Mr. Megani, and the judge found that at the first meeting between the parties in the May of 2016 that Mr. Megani repeated orally to Mr. Nutso the presentation of XY as being independent and conflict-free. And that's paragraphs 207 and 208 of the judgment, and the judge found that that was a continuing representation. Thereafter, what happens is that in the latter half of 2016, GIG or GIG, the company, enters into contractual agreements with XY for the provision of what were, in essence, financial advisory services. And in the December of 2016, MDM personally begins to seek advice from XY in respect of his personal position, albeit that was not documented by way of contract until later into 2019. Now, there is no dispute between the parties that the appellants were professional clients, as understood within the FCA categorisation, which I'm sure the court is familiar with. Now, there were a number of subsequent meetings between the appellants and XY during the course of 2016 and into 2017, during which XY begins to give advice to the appellants, first to GIG and then to MDM, as to how they might improve perceived efficiencies in their portfolios, reduce risk, increase return, and they are also introduced to certain structured products known in this case as MIN or MIN and HFT, which are structured products that the appellants had not previously invested in, and which the judge has explained at some length in section C of his judgment. I don't propose to explain the products in detail in the course of this hearing unless it becomes essential during the course of the causation and loss analysis, for example. Now, these discussions from late 2016 and then into 2017 and onwards made reference to the appellant's investment goals, and we'll come on to these later, but they included references to safeguarding assets and achieving returns in the range of 3% net of costs and diversification. Now, in late 2016, what becomes known as the Skew Base Fund makes its first appearance. And it is first mentioned as a possible opportunity by Mr. Megani to MDM in a video call in December 2016. Now, the judge has dealt with this, and this is purely for reference at paragraphs 321 to 341 of the judgment. At this stage, the fund is not fully formed. Its setup is in progress, so it is not referred to using that name during the call. It is referred to as a vehicle or structure with a Luxembourg compartment. And that is because, as the court will be aware, the Skew Base Fund was essentially an umbrella fund with several sub-funds within it, all compartments, as they were described. And the judge found that during that call, MDM was told that Mr. Megani was the person or entrepreneur behind the fund and that it was his project. That's para 337. But MDM is not told more than that by Mr. Megani at that stage. There are further calls and meetings between him, between MDM and Mr. Megani on behalf of XY, both later in December and twice in January. No further reference to the fund at that stage. And then the fund comes back into the discussions with MDM at a meeting on the 2nd of March 2017. And that is, again, for reference, addressed by the judge at paragraphs 411 to 444.
Sorry, paragraphs.
I'm sorry, 411 to 444.
Yeah.
So we have a meeting on the 2nd of March. It's referred to there, the fund, again, without the reference to its name, in a PowerPoint presentation. And I'll just show you, for context, and to try and bring the facts alive a little, how it was presented. And you'll find this, my lords, my ladies, in the unagreed bundle, tab 6. What you have in this tab, and I'm sorry, my lady, that all your files collapsed. It's particularly frustrating when that happens. What you have is an extract from the PowerPoint presentation that was presented to the clients. It's also a translation, because the dialogue between the parties took place in Italian, because they were both, their first language on both sides was Italian. And the slide in question that was presented to MDM in the context of the fund is at the first proper page. And you'll see what's described there. The investor is described in the box on the top left as SRL. That was Mr. MDM's corporate vehicle or investment vehicle. What's being proposed is that it invests into a regulated RIFE, which stands for Reserved Alternative Investment Fund. And you can see that the depository is flagged there with credentials of the depository. There is a footnote next to the word fund in the middle box, which explains that it's a managed vehicle from VP Fund Solutions Luxembourg. And you will see some bullets on the right-hand side, including references, for example, to a preferred manager, as well as costs. So there's no reference, it's common ground, that Mr. Megani's connections to the fund were never disclosed in writing. But the judge found that at this meeting, Mr. Megani's connection to the fund as entrepreneur and as owner of the general partner were disclosed. Nothing further, and as you will have seen from the slide, not in writing. Nothing else is said in respect of those connections. And instead what you can see from the document is what was conveyed was the involvement of independent professionals to manage the fund and act as depository. And for reference, my lords, my lady, Mr. Dalavedove, who was Mr. Megani's, effectively his associate in relation to the meetings with the clients, and he attended these meetings, Mr. Dalavedove, his evidence, which the judge refers to at paragraph 488, is that one of the reasons that MDM was interested in this potential investment was the involvement of a professional asset manager. And we've reproduced the extract, the relevant extract from Mr. Dalavedove's witness statement. And again, for your reference, it is in the unagreed bundle, tab 30, page 123, paragraph 87.1. And that matters because it confirms that XY knew that how and by whom the fund was being managed and operated was important to the De Montezemolo family. Now, MDM was subsequently supplied by VP Fund Solutions, the fund manager, with the offering memorandum for the Skew Base Fund HFPO compartment. It was known at the time as HFPO Centaurus, but it was then merged into the wider HFPO compartment. That was supplied to him on the 23rd of March 2017. Now, my lords, my lady, the judge addressed the offering document in overview, paragraph 446 of his judgment, including referring at Roman 10 to the inclusion of language concerning possible conflicts of interest. I just want to address that at this point, because in fact the language in the offering document did not shed any meaningful further light at all on any potential conflicts of interest. And what the offering document did is that it indicated that VP Luxembourg, as alternative investment fund manager, was responsible for portfolio and risk management and entitled to a fee for that. If we can just pick up, please, the offering document for a moment so that we've looked at it, and hopefully looking at it now will save time overall. It's in the supplemental bundle, please, at tab 7. I should say, my lord and my lady, that at least from my perspective, by far the greater amount of time I was going to spend was going to be on 1 and 2, including the factual background. So if I'm taking a while, please understand that it will hopefully accelerate once we've dealt with 1 and 2, which I know you'll want to hear my learned friend on. So supplemental bundle tab 7, you can see it's a lengthy document, this. And if we pick it up, please, at page 107, in the bottom right-hand side, so the bundle page, rather than the internal page numbering, is what I'm using.
And this is governed by Luxembourg law?
It is. I'll double-check that, my lady. I'm pretty sure that's right. But because it was taken into account by the judge, I just thought I'd show it to you. Now, we are here in the section on management and administration, and I'm just going to pick out certain passages. No doubt the court will look at the document in full, in the fullness of time, if it hasn't indeed already. And you will see in the second paragraph on this page, under general information, the fund has elected to be treated as an externally managed alternative investment fund. The general partner has appointed VP Fund Solutions Luxembourg as external alternative investment manager within the meaning of the law. You can, if one reads down, one sees that the fund has 2 different types of shareholders. I expect that sort of structure will be relatively familiar to the court, with the general partner and the limited partners who are the investors. That's in the bottom half of the page. And if we turn over the page, we then have 6.2, a reference to the general partner. We can see how that's described there. And then under 6.3 AIFM, the fund has appointed the AIFM as its external alternative investment fund manager in accordance with the provisions of the law to perform the portfolio management, the risk management, and the valuation function of the fund. And you can see that the AIFM may, upon instruction of the company, delegate the performance of some of those matters. And as we'll see, it did delegate portfolio management to VP Liechtenstein, the sister company. And you can see what portfolio management includes. It's at the bottom of the page. This includes, in particular, the monitoring of the investment, or portfolio management and risk management, I should say. This includes the monitoring of the investment policy, investment strategies and performance, risk management, liquidity management, and so on and so forth.
Subject to overall supervision of the general partner.
Absolutely, Melanie, absolutely. Now, turning forward, we can see the reference at page 112. So page 112, I'm under heading 6.4, Delegate Investment Manager. That's again the point about the ability to delegate to another entity subject to consent, and that was VP Liechtenstein. 6.5, we have references to the depository. And turning forward, the first reference one sees to conflicts of interest is at page 114. Now, this is within the section on the depository, which was VP Bank. And the simple point I make, and the sentence that is engaged here is potential conflicts of interest may nevertheless arise at the second paragraph from time to time and so on. This is dealing with conflicts between the depository and the fund, or the depository and the general partner, or others. So the simple point is this does not assist at all in terms of disclosure of conflicts of interest on the part of XY. My lords, my lady, there is a further, effectively boilerplate clause on conflicts of interest, which you will find at page 116. You can see what the first paragraph says. And this is, as is apparent from that paragraph, addressing conflicts of interest between the general partner, the AIFM, and so on the one hand, or other service providers on the one hand, and the fund on the other may be subject to various conflicts of interest in their relationships with the fund. So what's being addressed here is conflicts vis-a-vis the fund. So again, in my respectful submission, irrelevant to the issue before this court, which is conflicts between XY on the one hand and XY's clients or principals on the other. So insofar as the judge felt those matters, or insofar as those matters were in his mind, they do not disclose anything further. And they are obviously also entirely generic, as you will have seen.
Is there a suggestion that he probably took these things into account? I don't think so.
Perhaps not, my lady. I just wanted to square the point off, because it does feature in the judgment the reference both early on when the judge is summarising the contents of the offering documents, and when he comes back to deal with the offering documents at greater length later, one sees this being referred to in some detail. Now, I recognise it may be that I'm tilting at a straw man here, and I'm not trying to waste my lady's time. It may be that those things did not in any way come into the judge's reasoning, but in circumstances where, to the extent anything can be prominent within a very full judgment, where they were referred to in that way, I just wanted to square that point off. You will be aware of the references to the investment manager being VP Liechtenstein within the appendix, which you will have seen. I won't go to it. And the appendix disclosed that the general partner was receiving a management fee, and for this compartment, the HFPO compartment, that was set at 1%, and it explained that other fees come out of that. Now, XY seek to rely on that, and I will address in a moment later on why it does not assist. I note for completeness that for the min compartment, the fee was 0.6%, not 1%. And there is also reference to a possible performance fee for the GP in both compartments. Now, what then happens, returning to the narrative, is there are further meetings in which this investment proposal is discussed between XY and MDM, and a similar version of the slide that I've already shown you was presented. And on the 23rd of May 2017, MDM, through his company, invests 10 million euros in the HFPO compartment. There are then further meetings and a substantial amount of email contact during the rest of 2017. Detailed presentations are prepared, and it is the close relationship of client and trusted advisor that the judge found. And at no point during that time is any further information imparted by XY about its or Mr. Meghani's connections with the fund. We then move forward into 2018, and it's at this point in March that the possibility of gig investing in the fund is mentioned for the first time. So it's now the gig investments. Gig was expecting to come into some 200 million euros of what was described in the case below as new liquidity as a result of a previous transaction. And a meeting takes place on the 9th of March 2018, at which, according to the judge's findings, Mr. Megani introduces to GIG the possibility of investing in a Skew Base Fund. For reference, my lord to my lady, it's at paragraphs 565 to 563 to 565 of the judgment. And the judge concluded that it was explained that Mr. Megani was again the owner of the general partner and the entrepreneur who had developed the idea for the fund. There were then further meetings at which these matters are discussed further, but nothing further in the nature of the relationship between Mr. Megani and the fund is disclosed. The possibility of investing in the compartments is discussed further, and purely for your reference, and we've referred to this in our skeleton, there is a document in the underagreed bundle, tab 9, page 22, which shows how this was presented and includes the reference to VP Fund Solutions. And then the following month, in connection with the proposed investments, XY supplies GIG with a letter that confirmed that the investments being recommended were consistent with GIG's strategy and that all counterparties had, as the letter described it, passed through due diligence. That was being provided to the family, essentially to provide them with comfort. And just so you can see that, I'm in the core bundle again in the judgment. And it's paragraph, it's page 203. Of core bundle volume 1. Paragraph 6 to 5. You can see the references to XY being regulated. That's a reference to the Swiss parent company, and then to due diligence in the final paragraph. Now, there are then further meetings between the appellants and XY in June and July 2018. In August 2018, Mr. Nutso, now a director of GIG, is sent by VP Fund Solutions the offering memorandum, which he read. There were then further meetings, and then on the 25th of September 2018, GIG subscribes for shares in the HFPO and Min Euro compartments of the Skew Base Fund, with the transfers to pay for the subscription being made in October, and the total amount is 54 million, split evenly between the two compartments. And GIG invests a further 10 million euros in these compartments in the December of that year, again split evenly. There are ongoing meetings pursuant to this relationship in late 2018, throughout 2019. So you have it so that the numbers add up. There were some redemptions from the Skew Base Fund by GIG in 2019. In May 2019, they redeemed 8 million euros in the HFPO compartment. And in June 2019, GIG redeemed 6.8 million euros in the Min Euro compartment. We then have further investment by MDM in July 2019. Following further discussions with XY, he asks VP Fund Solutions for details of the Min USD compartment. He is sent by VP the offering document and share application form. That's judgment, paragraphs 706 and 707. XY assists MDM in completing the form, which MDM sends to VP Fund Solutions in September 2019, and an investment of 1.5 million in that compartment, Min USD, completes in early October 2019. That's paragraphs 710 and 711. And we then have the COVID-19 pandemic arriving in earnest in Europe in late February and into early March 2020. That causes market turbulence, which had very serious consequences for these compartments, and the losses incurred by investors are substantial. The judge records this at paragraph 69. And in broad terms, the appellants received nothing by way of distribution from the Skew Base HFPO compartment. GIG received about half the value of its investment in the Skew Base Min Euro compartment, and MDM, in respect of his later investment in the Min USD compartment, receives just over half his investment. And the court will be aware that the losses were substantial, essentially because of what the compartments invested in, as well as the internal borrowing in the fund. And I won't go into the products in detail, as I've said. Safe to say that these were complex, structured products, and the judge's account of them at Section C of his judgment was based on detailed analysis that the claimants team conducted prior to trial in order to explain them to the court. And a crucial feature of these products is that they could not recover, unlike equities, which may recover with the market. These products could not. You then compound that with a lack of diversification and the internal borrowing, and you have the wipeout effectively that occurs, because VP Bank, which was supplying the borrowing, wanted its exposure to be reduced, and of course it had first call. And what is significant about the fund, and another significant feature, is that the appellants did not have any ongoing visibility as to the precise nature of the products within each of the compartments. So you'll be aware that on XY's advice, there were some direct investments in these HFPO and MIN instruments from late 2016 onwards in smaller amounts. There one has visibility on the individual instruments. That was not the case with the Skew Base Fund, which makes the involvement of the fund manager and the investment manager obviously very important, and the full role being very important. And the visibility that we've been able to obtain, and which has served to support the analysis we've produced and produced at the first instance judge, was as a result of disclosure received during the course of the proceedings. So, my lords, my lady, with thanks for bearing with me. That's the potted history of the judge's findings as to how the investments were made and what we were told. Moving now into the grounds 1 and 2, which I propose to take together, inevitably one after the other, but essentially together. There is no dispute that the judge found that XY was the appellant's fiduciary, and there is no appeal of that finding. And indeed, it was Mr. Meghani's own evidence, as recorded by the judge at 12:45, that Mr. Meghani was seeking to and did develop a relationship of trust and confidence with his clients, and that his clients, like my clients, including my clients, did so place trust and confidence in XY. Against that background, my lord, my lady, there are two broad topics to cover. First, I've referred to the judge's conclusions as to what my clients were told by XY and Mr. Meghani in relation to his connections to the fund. And let's be clear, the case advanced by XY throughout the proceedings, including at trial, as to what it had disclosed was that Mr. Meghani was the entrepreneur behind the fund and that he owned the GP. Nothing else. And that's the only disclosure found to have been made. Judgment paragraphs 1173, 1250.
Sorry, paragraphs
1173.
Yep.
1250.
Yep.
1253. And elsewhere. Now, I have not addressed you yet on what my clients were not told by XY, and I'm going to deal with that first. Then I'll come on to the legal analysis. I'm conscious, I'm straining to get to the law as well, but I just want to frame this correctly, because what we were not told is critical. And the legal analysis, the key issues in that regard, in my submission, are: 1, how the obligation of disclosure is best analysed. Is there an obligation or duty to disclose matters in circumstances where you are facing a potential conflict of interest? We say yes. Or does it just come down, as XY say, to the question of informed consent? And it's not an arid point. and I just really give a sneak preview on the issue here, but it's not an arid point. If you are facing a potential conflict of interest as a fiduciary, you have a duty of full disclosure, transparency, and it is a heavy duty. Informed consent only comes in if and when the duty is complied with, in my submission. If the duty is not complied with, there can be no informed consent. And in any case, it is the prior stage.
I don't quite understand that, but you'll come to it, so I won't trouble you now.
Very well, Newey. Now, let me address you, if I may, now, and we're still dipping back into factual matters then at this stage, on what my clients were not told. And if I could address you on this, please, first by referring to my skeleton. And you'll find this in Core Bundle Volume 2. And I'm going to pick it up, please, by referring you to the structure chart, which we've included at page 470 of the bundle.
Just hang on one moment. I've got a dreadful feeling that in my cannibalising the bundles, I might have left that page in my room. If anyone else were able to supply me with that page, I'd be grateful.
Mine is marked up, I'm afraid, my lord.
Here
we go.
Thank you very much. My lord has solved my problem.
I'm grateful. Thank you, my lord. So you should have now page 470 in front of you. Now, let me just take this in stages. So this is a diagram representing the full arrangements insofar as we're now aware of. And starting in the top left, you have Mr. Megani, who was the 7th defendant in the proceedings. He was, this was not held back, the CEO and director and 100% owner of XY. XY give, and moving to the right-hand side, give investment advice, as the judge found, to GIG and MDM, the appellants. On the strength of that advice, they invest into the Skew Base Fund, which was the second defendant, you can see that. And the Skew Base Fund pays fees to the general partner, so that's the arrow going to the left. And we know that the fund is paying the general partner a fee, and the level of that fee is set out in the offering document. We also know
that there's a blue line that says money flows of which these were aware in principle, but they knew the amounts, didn't they, going to the general partner?
Well, we knew the percentage. So specific amounts could have been derived based on our own investments. Obviously, what we didn't know was how many other investors there were and what the total amounts being paid to the general partner might be, because they would have been referable to the full pool of investment going into the fund. So we have, and we don't take a point on the number in that sense, the absolute number. Absolutely, and absolutely no. My learned friend asked me to clarify that the payments that are indicated, the figure there reflects the total pool of investments.
Which is why you say you didn't know that number.
Exactly. Now, and so they are paying the general partner. We also know, indeed, and this was effectively a selling point, and I've referred you to Mr. Delaveda's evidence, who recognised the importance of the professional asset manager. To the GP is instructing the VP parties, VP Luxembourg D4 and VP Liechtenstein D5, as fund manager, so far as Luxembourg is concerned, and investment manager, so far as VP Liechtenstein is concerned.
And that's, as I understood right, that's a statutory requirement of the structure of a Luxembourg fund of this nature.
It is. And so, and you'll I showed you the references to externally managed and so on. Now, and so the general partner is delegating important roles that the judge described as core functions, namely portfolio management, risk management, and also, in this case, valuation. And one expects the fund manager and investment manager to be paid substantial sums for that work, and on the face of it, they were. What we're not told, that the VP parties, VP Fund Solutions, the fund manager and investment manager, are subcontracting a very substantial role to an undisclosed and unregulated entity, which is a new company with no track record in the funds industry at all, called Twinkle. And you'll see the red line in an L shape going out from VP and up to Twinkle. As the judge records 1194, it is undisputed that we were not told about Twinkle's role or the payments being made to it. There are a handful of references, which I would respectfully describe as passing references, to the possibility of an investment advisor in the offering document, but there is no defined term explaining what that is. No investment advisor is identified by name. It's not explained what it does, how much it is paid, let alone that it is a completely new entity with no history in this market. We are also not told that...
Sorry, can I just pause there? Why does that matter if it's a creature of Mr. Megani? Why do we need to focus on the particular vehicle rather than who in substance is playing the role or receiving the money?
Mr. Megani also did not have any prior professional experience in fund management of this kind. So the point stands equally for him. But I think my Lord's right. If it had been a direct line to Mr. Megani, the non-disclosure would have been equally serious.
Well, I understand your submission. That's where we have to get into what was understood by Mr. Lutzer.
Absolutely.
And just to be clear, Twinkle, as it happens, is owned by Mr. Megani. Suppose it had been an unconnected entity, similarly, without the experience. What would your case have been then?
Well, the cases, as we'll come on to, refer to the need, if it had not been connected, we would have still had a conflict of interest, of course, because Mr. Megani would have owned the general partner.
Leave that on one side. You're focusing on Twinkle. I mean, the advice might have been the same in a sense. You say you've ended up with advice coming from an inexperienced, unregulated party. Would that have been a cause for complaint?
It would, but in a slightly different way. The cases indicate that when you are a fiduciary and you are encouraging a client or proposing an arrangement that gives rise to a potential conflict of interest, which this would have done, and that's why I mentioned the general partner element, because that's what engages or brings up the conflict. The cases suggest that in that situation, you as the fiduciary have to give disclosure of all material facts and matters, generally.
But in relation to Twinkle itself, there wouldn't have been any conflict.
Not in relation to Twinkle in that example.
So when we're told about the inexperience and so on, how does that fit in?
Well, when the fiduciary is under an obligation to disclose all material facts and matters, in my submission, that is a broad obligation. And it is not limited only, although clearly there is an acute focus on matters that give rise to attention and to the conflict itself. The cases go wider than that the fiduciary duty has got to make disclosure of all material facts and matters, and matters that give rise to the conflict.
So suppose the investment advisor hadn't been Twinkle, it had been an individual about which Mr. Megani had known something to his discredit. That would have been something that Mr. Megani, XY was obliged to disclose.
Yes, and it's for a slightly different reason, as I've said. He still wants these clients to invest because he's taking fees at least at some level through the ownership of the general partner and being the entrepreneur behind the fund. That gives rise to a tension between what's in his own interest and what's in his principal's interest.
So I'm sorry to interrupt you, but I may be taking you ahead of where you want to be at this stage, but whilst we're looking at this, do I understand that your submission that there's a duty to disclose all material facts means, at least in the context of this case, facts that are material to a conflict of interest?
Facts that are material to conflict of interest, but also to the nature of the investment that's being proposed. And it may be, I'm not trying to sort of play with words, it may be that they come to the same thing, but let me just, if I can just perhaps try and answer by developing the point.
I would just like to write this down, because I can entirely understand how you can have a fiduciary duty, in conceptual terms, positively to disclose something which is material to a conflict of interest because of the no conflict rule. But to describe a duty to disclose anything that relates to the transaction as a fiduciary duty, speaking entirely for myself, needs tethering a bit more carefully.
I understand that, my lord, entirely. But if it's material to the investor's decision or the principal's decision as to whether to proceed, because that's what engages, in terms of tethering, my lord, that's what tethers us back to the conflict. Because if the fiduciary is sitting there, putting a transaction on the table, where it is in his or her interests for the principal to go ahead.
Well, you've come back to conflict then.
I appreciate that, but I'm showing why that is quite a broad, the effect of that's quite broad. Because if it's in my interest for you to proceed, you as investor are sitting there, you need to know fully the nature of the investment proposal. If I present the investment in a way that is partial or incomplete so as to make it more attractive, or with the effect of it being more attractive, because the cases also say that it doesn't turn on what the intention was, then the investor is proceeding without full disclosure in a manner that is beneficial to the fiduciary, but potentially at least detrimental to the principal, because the fiduciary wants that arrangement to proceed. It's in their interest.
Can I just try separating two things? I don't know that they do separate. One is Mr. Magani, the general partner, wanted as much investment in these funds as possible, obviously, because the general partner was going to get money based on what was in the fund. So there's that. Secondly, it's going to get money by reference to how the funds perform. I haven't actually checked, but I assume that the payments to the general partner are based on what's in the fund for the time being.
Yes, ma'am.
So in that respect, there's no lack of alignment between the general partner's interests and the investor's interests once the money is in the fund. So you want your investment advisor to be a good investment advisor so that the fund is maximised. There's no conflict between the general partner's interest in having a good investment advisor and the investor's interest in having a good investment advisor.
I didn't want to cut across my... But what the fiduciary may think is a good idea so far as concerns an investment advisor may be very different from what the principal thinks. The principal is entitled to full disclosure so they can make their mind. And that's one of the vices. I mean, to be clear, my lords, howsoever one characterises the duty of disclosure, in this case, on my submission, we succeed. I don't require, in order to succeed on the facts of this case, some very expansive duty, and I'm not aiming at some exceptionally expansive duty. The duty I invite the courts to find, and I was going to come on to this, but is where the fiduciary is facing a potential conflict of interest, they must give disclosure of all material facts and circumstances, including such matters as go to the conflict of interest, so that the principal can then make up their own mind. Because there is a tension, and even if in theory everyone should want the fund to succeed, what one investor may think is a good idea in terms of arranging a fund may be very different to what another may think. That's the point of the full disclosure and the transparency that's required.
But I'm sorry to press you. The way you've just formulated is all material facts and connections as to matters which go to the conflict of interest, or including those that go as to the conflict of interest. If we're, on the facts of this case, only concerned with facts which go to the conflict of interest, then we don't need to worry, do we, about whether the disclosure obligation goes wider than that. And I just wanted to try and clarify my mind when we're looking at what you say the factual position is and what your clients weren't told, whether we are focusing on a case, on your case, that there was a relevant breach in failing to disclose matters which went beyond those which go to the conflict of interest. Is that part of your case?
I don't require that. I've put the matter before you in the way I have, because the cases that I intend to rely on do refer to the position in that way. And so I don't want to cut corners on that. But we do say that there was a clear conflict here. That's the existence of the conflict is not in dispute. And what when a fiduciary is faced with a conflict, they have to disclose everything so that the client can make their own mind up. And if one presents a financial investment in a way that is not complete, materially incomplete, because it's got to be material, and which results in the presentation of that investment not being full, such that the investor is drawn in without realizing exactly how the investment works and who's involved, for example, in this case, in the selecting of the investments, then that is going to go, it's a material fact and circumstance, but it will go in my submission to the conflict because the investor is being encouraged to invest without sight of the full factual position. And that is in the fiduciary's interests, but not in the principal's interests. If one is contemplating an investment which would be to the benefit of the fiduciary, and the fiduciary is sitting there in front of you and saying, invest in this, I highly recommend this, you are entitled to know the full position so that you can decide whether that is a good idea or not.
Can I just test it at a moment? Forget about this particular fund. Suppose you have an investment advisor who suggests that a potential client invests in X fund with which he's known to have a link. And the individual behind it knows that if you look at some rating of investment funds, there's a better one. Obviously, he favours his own fund. Is there an obligation to inform the potential client of every fund that might be considered to be better?
Well, in that situation, you'd expect the fiduciary at least to say, and my lord, I'm answering on my feet, but to at least explain that there may be other funds available and you may wish to consider alternatives. I mean, as a minimum, that's the point of the fiduciary relationship. And we are in a fiduciary relationship here. We're not in some non-fiduciary investment advisor scenario. We're in one where the principal is entitled to and does trust the advisor.
You're quite right. I'd need to construct slightly different facts. It would have to be that the person thought it was the best possible fund, but was aware that some ranking came up with a different answer.
Well, Saxon Woods tends to suggest that the question is to be analysed objectively. It's paragraphs 54 and 55. And my lord, my lady, if perhaps we place ourselves in the position of the principal, who trusts the advisor implicitly. The advisor saying, invest in this fund, I'm connected to it. It's great. But the advisor knows, the fiduciary knows, that in the market, some independent ranking system has judged a different fund to be better, more suitable for that client. As the principal, you would expect to be told that, or at least to be given enough information for that to be reasonably clear. If you sat there and that was withheld from you, you'd consider that the duty of disclosure had not been complied.
Does that depend upon the sophistication of the investor?
Well,
I mean, if the investor happens to be someone who is themselves an independent financial advisor, they're doing this with their private funds and they're well aware of that.
Well,
still an obligation of disclosure?
Well, there are cases, my lord, about where the fiduciary duty is found to have been moulded or narrowed. And Medstead, for example, was such a case, and that was explained. It was clear from Medstead in my submission, but it was explained again in NG. But this is a case, and there's no dispute about this or challenge to this. This is a case where the judge found that it was the full fiduciary duties that were owed, unnarrowed, and that's apparent from the judge's reasons for refusing to grant permission to appeal. So it may be that in the scenario that my lord posits, one looks at it from the other perspective, which is, or maybe it's the same perspective as my lord is floating, which is what are the range of duties there? And in certain cases, they can be narrowed, whether the contract says so or the circumstances say so, but this is not that case. My lords, my lady, we are exploring the principles, but it will all come out in the...
It's my fault. I've blown you off course because I really wanted to try and clear my mind on what I was looking to get out of this chart in terms of
course,
your submissions about what you say you weren't told and should have been told.
And my lord, hopefully once we've looked at some of the authorities, the reasons I say what I've said will become clear.
And your point about this chart is, as I understand it, relatively simple, which is one believes or is told, you say, that it's the VPs who are doing the heavy lifting, but actually it's Twinkle. And you don't know that.
In a nutshell.
In a nutshell.
And I'll come on to some of that in a bit more detail. So that was point one. We were not told that. Point two, we're not told that Twinkle is owned by Mr. Megani himself. And point three, we're not told that in addition he is the managing director of Twinkle, as the judge found. Now that's not recorded on the chart. Now his role as shareholder, his role as managing director, and Twinkle's role as, how it's now been described by the judge, investment advisor, none of those things were publicly discoverable. So I'll say that again. Twinkle's role in this structure, Mr. Megani's ownership of Twinkle, and Mr. Megani as managing director of Twinkle were not publicly discoverable. He was not a de jure director, and he gave evidence at trial, supported by colleagues, that he had no meaningful control over Twinkle, save in relation to a totally separate, limited real estate consultancy line of business. But the judge rejected that evidence and found that he was in practice the managing director. And you'll see that in a couple of places. One of them is 1296, Roman 1. And what you can see from this chart is that the lion's share of the fees being paid to the VP parties are paid on to Twinkle. So of 7.74 million euros received by the VP parties, over 6 million euros is paid on to Twinkle, so approximately 80%. And my clients were told nothing about that.
So that's the fourth point. 1, 2 and 3 are about role, and this is now about receipts of money.
My lord, yes.
Is that-
And because it goes to the significance of Twinkle's role. And my lord, you will also see that there are other contractual agreements here with between other entities owned by Mr. Megani. The general partner has an undisclosed contract with Twinkle for support services. And then the leader logic entities in the bottom left-hand corner are introduced in 2019 and 2020. Now that's very much a snapshot. We have explained in our skeleton at paragraph 444 of the bundle what we say the required disclosures were.
So it's 444 of,
Of Core Bundle Volume 1. And perhaps I can deal with this quite briefly.
Sorry, which paragraph are you in?
I'm sorry. It's at the top of the page in 444. I forget the paragraph number.
27.
Thank you.
Yes.
And it's as my lady, Justice Asplin says, it's one thing to be told that Mr. Megani is the entrepreneur behind the fund and or owning the GP, and for the offering document to set out the total fee payable. But in the same breath, we're being told that GP is engaging a substantial financial institution, VP, to act as external fund manager and investment manager, such that, as the judge found 938 and 945, it is not conducting much of the day-to-day work of running the fund and retaining what the judge describes as a residual or supervisory role. And consistent with that, you are entitled to approach it on that basis. But what you don't know is that, in fact, there's another entity owned and controlled by Mr. Megani receiving most of the investment management fees. In fact, the entirety, as I'll show you, of the portfolio management fees for investment selection. And just to put some colour on Twinkle's role, and I appreciate you will have got the details of the judgment, but what have we learned during the course of the litigation? There was a bespoke IT system developed between Twinkle and the VP parties, so that Twinkle could send what were informally described by VP personnel as orders straight to VP via the bespoke IT system for what the judge described as semi-automated checking and then execution. And so that you have the references, my lords, my lady, the interface, the bespoke interface called a SOAP or SOAP interface is referred to at 855, and the semi-automated nature of the process conducted by VP when it receives the orders is at 878 to 879. At 885, the judge confirms that it was Twinkle's job to identify the instruments that should be bought and sold by the fund. And we've given you examples in the unagreed bundle of Twinkle negotiating the instruments directly with the counterparties. So approaching a third-party provider of these instruments, and Twinkle negotiates the terms of those directly with no VP involvement at all. And indeed, in the example we have, and I'll provide you with a reference to the bundle at tab 16, unagreed bundle, page 52, you can see that Twinkle is being referred to by the provider as the client. And the final term sheet for the instrument is negotiated exclusively between Twinkle and the counterparty, with no reference to VP at all. And that is how it was consistently done for these compartments. Some other, some more colour for the court. Mr. Negro, who worked for Twinkle and who reported to Mr. Megani, was described by VP Liechtenstein's most senior witness, Mr. Conrad, at trial as the lead analyst for the HFPO compartment. That's paragraph 883, with the judge recording at paragraph 882 Mr. Conrad's evidence, which the judge accepted, that Twinkle's role was to select the products these compartments invested in.
But didn't the judge also find that that was what Mr. Nutso was fully aware of.
I will come back to that. I understand that point entirely, my lord, and I will be dealing with that. And I'm conscious, my lord, I think raised the question of what Mr. Nutso knew earlier as well. And the key point, my lord, is it was never, there were a number, but a point on the law and on the legal analysis is that Mr. Nutso was never told those things by XY. So the judge's conclusion, to which my lord is, if I'm speculating correctly, referring to, was a conclusion about what Mr. Nutso must have divined for himself, the matter not having been disclosed to him in that way.
Divined from his knowledge of how Luxembourg Funds works and what it means for someone to be the man whose product it is.
Well, maybe, my lord, but I'll show you also that what the judge said is very, very difficult, and I do say impossible to reconcile with XY's own evidence on that issue. Because XY's own evidence through Mr. Megani was that XY had no relationship with the fund and provided no services for the fund. And yet the judge has concluded that Mr. Nutso thought that XY was selecting the investment.
But is there a challenge to that finding of fact?
That comes up. I've got permission.
I'll keep quiet and let you make your submissions as you'd like to. I'm sorry.
No, my lord, I welcome the interruptions. If my submissions are not sufficiently focused, then I'd rather address my lord's question.
No, it's my fault. I shouldn't have jumped in.
Not at all. Now, the fund, as I've described it, and the role of Twinkle, it was set up in that way, and we have furnished the court in the unagreed bundle at tab 2 and at tab 3 with internal emails from VP explaining that this is how the fund was deliberately set up. And we can see, I could perhaps just show you those quickly, very quickly. Tab 2 of the unagreed bundle. It's page, I'm sorry, tab 2, page 7. What you're looking at here is an internal email exchange amongst VP Fund Solutions personnel. Now I'm looking at the email at the top of the page. It's an internal email exchange amongst VP personnel.
So sorry, it's my fault. Which page are we at?
I'm sorry, page 7 in the bottom right hand.
Page 7, sorry.
Tab 2, page 7.
Thank you.
What you're looking at is an internal email amongst VP Fund Solutions personnel sent during the time when the Skew Base Fund was being set up. And you can see what's said by Ms. Souter at the top. In regards to the order routing for certificates portfolio, this was a reference to what became the HFPO compartment. There is one point which needs attention because of the advisory setup. The advisor is, as we now know, Twinkle. Skew Base may be looking for a swift and timely implementation of the orders instructed to us. You can see the language of instruction. This implies that if you'll ask for the orders to be executed within max, the language of orders, within max 30 minutes or 1 hour from the advice instruction, someone in our investment management team shall always stand ready to take orders. As an alternative, we could require from Skew Base's team that they give us a 3 to 12-hour notice when they plan to instruct trades. And just on the same point, in the next tab, I'm at page 9. We have further internal exchanges at VP. I'm looking at the email in the middle of the page from Mr. Rees, who was the CEO of VP Luxembourg. Dear all, we discussed this sub-fund with XY. The investment strategy is indeed very time-critical. Timing is a key item. And for a right with this dedicated investment strategy, the same diversification as report apply for SIFs. That's another sort of type of vehicle. Investment restrictions are not applicable by law. And the restrictions are the limits on what the fund can invest in. And they're set out in the appendices, which you'll have seen. And if you look at the bottom of the page, in the prior email, a colleague explains, I would recommend to minimise the restrictions as much as possible and work with internal guidelines. Willie, that's a reference to another individual at VP Fund Solutions, Mr. Zahenda, mentioned that the time between advice and transaction is very critical for the fund's performance, therefore manual checks. That's why it was set up in a way that allowed the investment selections being put forward by Twinkle to be the subject of what the judge described as semi-automated checks.
Now, you can complain about the role of Twinkle, but it sounds as though if you are to have Twinkle, there's very good reason for structuring it this way, because everything's time critical.
Well, my lord, what we don't know, and I'm going to focus on what my clients were told, is that the investment manager's role is going to be limited to a semi-automated checking process. They are described in the offering document as responsible for portfolio management and risk management. And we've also provided you with some emails, just by way of example.
So I just want to write this down. This is I think I'm writing down as the fifth element of what you weren't told, which was that there was going to be a semi-automatic checking process by the portfolio manager.
At this stage, what I'm doing, and I'm sorry for not being clear, I apologise, I'm trying to just give you a little bit of colour on the nature of Twinkle's role that we were not told about. So I'm just trying to paint a little bit of a picture for the court.
But this isn't, is it, a criticism of VP and for performing its role as portfolio manager?
No.
The judge expressly dismissed any criticisms of that and dismissed the suggestion that it wasn't itself performing the portfolio management role as properly understood in executing the transfers on the advice of an investment advisor in this way.
Of course, my lord, I'm very conscious of the judge's findings and of the limits of what I am entitled to pursue in this court. No, what I'm focusing on is what we did not know about Twinkle's role, the nature of that role, and how expansive it was.
When I say so what, I'm not being facetious. What are you asking us to get out of that?
Well, I'm just trying to bring it to life a little, my lord. Nothing more than that. And my lord, taking the court's hint, I will just refer back then to our skeleton, where we've explained and made reference to internal emails sent between VP and Twinkle, where Twinkle is referred to as, and I appreciate this is effectively an internal colloquialism at the time, but Twinkle is referred to as the investment manager. An example, and I'll give you the reference, my lords, my lady, is in the unagreed bundle, tab 12, page 31, where the head of fund administration at VP Fund Solutions is emailing Twinkle and asking them for various information in relation to the funds, and he says, as investment manager of the compartments, can you provide us with this information? And we have further examples also referred to in the skeleton and provided to you in the bundle, where it is Twinkle that is asked to and does provide what is described as the report of the investment manager for the purpose of board meetings of the general partner. And the reference in the skeleton is 65 and 66. And can I just close with two further factual points, if the court will indulge me on those. The first is the point that the entirety of the portfolio management fees are being paid to Twinkle, as well as the performance fee.
So the entirety of the...
So VP, the VP entities, VP Luxembourg being the entity into which the fees come from the general partner, are entitled to a range of different fees. And perhaps I can just show you this so that what I'm saying is sufficiently clear. I'm in the supplemental bundle. Tab 3. you will have in front of you the Alternative Investment Management Agreement by which VP Luxembourg was retained as fund manager. Now, just for speed, I'm going to go straight to the list of fees and expenses payable to VP Fund Solutions Luxembourg under this agreement, which you will find page 32. I'm afraid the numbering has suffered from several different ways of numbering being applied. Hopefully you can find it. It's the penultimate page. And so you will see here what the general partner has agreed to pay to VP Fund Solutions. There are payments at the top in respect of AIFM service, which are described as capital substance requirements, risk management, and it's 0.03 of net asset value. There is then portfolio execution management, 0.05% of net asset value. And then you will see portfolio management, the core task, 0.5% per annum on average, total asset gross of any fees payable each semester in arrears. That's the lion's share of the fee that VP is being paid under this agreement. And then beneath that, you will see reference to a performance fee, which is calculated in a particular way set out. Now, what we have established by going through the disclosure and what we showed the judge at trial is that all of the portfolio management fee and all of the performance fee go to Twinkle. And can I just show you that, the calculations, so you know where they are. In the unagreed bundle, we can put away the supplemental bundle and open up the unagreed bundle, please. And it's tab 36, please. Now, I just wanted to explain this to you because it may not be obvious from, I want to just give you the reference and leave the court to work it out for itself. Now, what we have, this is a document we have produced and produced at trial. And what we have done is by going through the disclosure idea and looking at the invoices rendered by VP to the GP, and then in turn, the payments by VP to Twinkle, we have demonstrated, and this was not challenged at trial, that on each occasion, every single month, for which documents were available, which is most of them, as you can see, or every single semester, because it was billed on a semester basis typically. VP's fees, so you can see payment from, I'm in the first column as an example, payment from SBGP, payment to VP Lux, and you can see what is itemized. An administration fee, an AIFM fee, the execution management fee, a portfolio management fee, and a performance fee. And every single month, the portfolio management fee and the performance fee are paid on to Twinkle. And you can see that in the second row. VP Lux to Twinkle, fee according to their agreement, and it's the total of the two sums mentioned there. So what's happening in practice is on every occasion, VP Luxembourg is paying the portfolio management fee and the performance fee to Twinkle.
And while I don't think it matters, have you got the agreements between Twinkle and VP Lux?
We do. It is available.
And can one see that that would fit these with these?
No,
payments?
the figures don't match. Now, the last document, and I am grateful to the court for listening to these points, because they do provide crucial context in my submission, is the Deloitte report. I'll just show you this quickly. We're in the same bundle, please, tab 26. For context, a detailed investigation was conducted by Deloitte at VP Bank's instruction because VP Bank had suffered significant losses. You'll know that VP Bank was lending to the compartments and it suffered significant losses as a result of the collapse of the compartments. So Deloitte were engaged and in the immediate aftermath and produced this report on the 7th of May 2020, as you can see on the first page. This is a report that was disclosed by the VP parties part way through the trial. Now, I won't dwell on the prior pages. What you can see, for example, at page 98 in the bottom, looking at it in landscape form in the bottom left-hand corner, are that many people were interviewed for the purposes of this report. And at 110, cutting to the chase, because this is extracts, my lord, my lady, the full version is available. At page 110, you can see what Deloitte's conclusions were in relation to Twinkle. I'm in the right-hand side of this. You can see a structure chart in the middle, which reflects the arrangements. And under observations on the right-hand side, you will see what's described. While not formally, the third bullet, while not formally appointed or disclosed in the offering document of the fund, Twinkle Capital effectively made the investment decisions in the compartments. VP Fund Solutions Liechtenstein, as formally appointed investment manager, only reviewed compliance of the trades with applicable limits, didn't own the decision. You can see what's said in the final bullet point about how investment decision making is being made by an unregulated, not formally disclosed entity. And you will see similar observations on the final page in the clip 111. There's obviously a lot of detail on this page. I draw your attention to what's said towards the bottom of the page. There's a blue box containing the word evaluation, and you'll see this similar language to the right-hand side as was found on the previous page. Finally, Mr. Meghani's role in Twinkle as de facto managing director was something that he denied to the bitter end at trial with the support of colleagues. And I'll just provide you with the references. Mr. Meghani's denial in written and oral evidence was rejected by the judge at paragraphs 113 of the judgment. And the exercise of presenting a false picture as to his own role was one that he engaged in with his colleague, Ms. Goveni. She was employed by Twinkle and the general partner from mid-2018. And you will see the judge dealing with her her evidence on this at 137 and 138, where she gave internally contradictory witness statements about Mr. Meghani's role in the fund, and Mr. Faleschini also sought to present a false picture, and the judge's rejection of that evidence is at 126. And I stress this, and it comes back to the point my Lord Justice Popplewell raised earlier. Mr. Meghani denied to the bitter end, with others, having any managerial role of Twinkle that might affect these matters.
And why do you stress that?
Because it is impossible to reconcile that denial with the court's conclusion at first instance that Mr. Nutso nevertheless believed, even though this was not disclosed to him by anyone, nevertheless believed that XY, which he knew was directed by Mr. Meghani, was effectively selecting investments. Mr. Meghani himself denied any involvement in Twinkle, which was doing the investment selection.
So where does that fit into the appeal?
Well, I'm maybe taking matters out of order, but I'm just trying to explain the relevance of those findings now. Now, with thanks to the court for bearing with me, now the legal points. Now,
Meaning we should, so to speak, have to hand the authorities bundles, not the supplementary or the unagreed.
I think that's right. Now, as you will know, my lady, my lords, our position is that whether the court approaches matters via ground 1, the scope of the duty, or ground 2, the informed consent angle, we succeed. But the distinction between those two grounds is not without wider significance. Now, my Lord Justice Popplewell has already indicated this in the way that he's granted permission to appeal, but I would also suggest respectfully that it's very important for fiduciaries, financial advisors or otherwise, to know and have a clear understanding of what their duties are. And so, starting point for the analysis here, the judge found that XY stood in a fiduciary position in relation to the appellants. XY denied it at trial, but the judge found that. There's no appeal. The starting point, then, starting from the ground up, is the duty of undivided loyalty. No dispute that the authorities confirm that's the distinguishing characteristic. And you know that our case is that as part of that duty, facing a conflict of interest, XY was required to disclose the matters listed in paragraph 27 of our skeleton, to which I've referred. Because, for the reasons we explain at 28 and 29, which I may come back to, they strike to the heart of XY's duty of loyalty. It is material to understand what Mr. Meghani's interest in the fund is, in full, and it is material to understand the nature and operation of the fund which XY is recommending that my clients invest in, and which XY, through Mr. Meghani, has a vested interest that we invest in. Now, we can see how the judge approached it if we pick it up in the core bundle at 1240. So it's page 359 of Core Bundle Volume 1. And the judge starts at 1240 by quoting the well-known passage of the judgment of Lord Justice Millett in Bristol and West Building Society in Motley. And we see the references there to the core duty, the single-minded loyalty of the fiduciary, and then the core liability having several facets. And as the Lord Justice Millett said, XY may not act for his own benefit or the benefit of a third person without the informed consent of the principal. We then see the quote below from Mr. Justice Newey's judgment in Glynn and Watson. And at the very bottom of the page, one sees the language, someone who has agreed to act in the interests of another has to put the interests of that other first. And then the language of informed consent. Now, we turn the page, if we look down, the conclusion that XY owed fiduciary duties is at 1245. And you can see what the factors that the judge relies on. Provision of consulting services concerning the investment of very substantial sums of money, the developing of a relationship of trust and confidence, and then the fact that at the start of the relationship, XY's website described its business in terms of being independent, unbiased, and conflict-free. Now, as we explain in the skeleton, the right approach in principle, and I would respectfully suggest, I'm conscious of who I'm in front of today, in line with this court's decision in Medstead, is then to ask the question of how the fiduciary duty fits in with the contractual arrangements and what duties it includes. Now, the judge, on the face of the judgment at least, appears instead to have approached it as a more narrow question, which is the question of proscriptive or prescriptive. And one can see that at 1247 to 1249. Now, in my respectful submission, one shouldn't get drawn overly here into semantics. The focus should be on the substance, in much the same way as whether an injunction is described as prohibitory or mandatory has been described as a barren question. Focus should be on substance. Now, the judge, in his reasons for refusing permission to appeal, and I'll just provide you with the reference, it's Core Bundle, tab 9, page 417, paragraph 2, in fact confirmed that there was no narrowing here. He was applying the full fat, if I can put it that way, the unnarrowed, undiluted fiduciary duties. And there's no challenge to that finding. So far, so good. But we mustn't water down what that duty involves. That's something that this court cautioned against in NG. And we quote that at paragraph 35 of our replacement scheme. You mustn't dilute it down. So what is the nature of the undiluted obligation here? And we say that if a fiduciary is contemplating a transaction or arrangement involving his principal, which has the potential to compromise his duty of undivided loyalty or her duty of undivided loyalty, then he or she is under an obligation to make disclosure to the principal of all facts and matters, including such facts and matters, and in particular such facts and matters as relate to that potential compromise, and to ensure that the principal has full and accurate knowledge of the circumstances of the proposed transaction or arrangement. And the fiduciary cannot hold any material fact back. Material fact. And that is either, on our analysis, an obligation emanating from the duty, the overarching duty of undivided loyalty, or an incident of the no conflict and no profit duties. And it is not, we say, to be collapsed into the question of informed consent, because the prior question is, was the duty complied with? Now, I'm going to look at some of the authorities now. My lady, I see my lady.
I'm confused by that. Was the duty complied with? That's another conflation, isn't it, of a different kind. Does not one start with what is the duty? Is there a breach of that duty? Has that breach been neutralised as a result of informed consent? Whereas I think what you were just saying, in effect, does conflate, perhaps to some extent, the existence of a duty with the breach of the duty. I don't know, I'm sorry.
No, I'm grateful, my lady, I'm grateful. That may have been a slip of the tongue on my part. Duty, compliance, and we say if compliance, you move on to the question of informed consent. And you'll see in some of the authorities that we look at, they refer to the two being required: compliance with the duty and informed consent. That's why I've expressed it in that way.
Mm-hmm.
So can I be clear? What do you say the duty was?
The duty is to provide full disclosure of all facts and matters which relate to the potential compromise of the duty of undivided loyalty.
So this is independent of the duty to avoid conflicts.
Well, my lord, we say you can achieve, you can get there either through. I mean, whether this is overly theoretical, I don't know. My lord will know that, tell me. But we start with the overarching duty of undivided loyalty, and the authorities appear to suggest that from that one then derives the no conflict duty, the no profit duty.
But now one could express a no conflict duty as a duty not to put yourself in a position of conflict without informed consent. Would that be all right?
We would respectfully submit that what's required before you get to informed consent is the disclosure of all material facts.
But why wouldn't that formulation be fine? A duty not to put yourself in a position of conflict without informed consent.
Because one gets into no man's land around what the obligation of the fiduciary is in terms of providing information. Because what we see from the cases is that, for example, putting on inquiry.
Well, then you wouldn't have informed consent.
Maybe so, but in my submission, what's required in this area is clarity as to what the fiduciary is required to do. Because what is required to get to informed consent?
Can I just stick with my hypothetical statement of the duty? Duty not to put yourself in conflict without informed consent. And that, you say, is not good enough, doesn't provide clarity. So, to be clear, is it your case that even though the fiduciary has not put himself in a position of conflict without informed consent, that isn't necessarily good enough? Is there scope for an independent breach, even though the fiduciary has not offended the principle of putting himself in a position of conflict without informed consent?
We say, with respect, yes, because the fiduciary, as a corollary of whether the undivided loyalty or the no conflict duty, has to make disclosure to the principal of all facts and matters going to the compromise, as well as in this case going to the nature of the proposed transaction.
So, to be absolutely clear, in circumstances where there is a potential conflict, but in fact the principal has given informed consent, there can still be a breach by non-disclosure.
Yes, I can see that it may effectively, as the authorities put it, be negative.
I mean, what's the point of it? I don't quite follow.
Because it identifies what the fiduciary has to do.
So he has to do something other than avoiding putting himself in a position of conflict.
He has to provide full disclosure of the position. So that's an obligation on them.
So but expressing this in specific terms, suppose the principal knows everything full well. The fiduciary commits an independent breach by not telling the principal what he already knows.
Might be one for me to consider over the short adjournment.
I mean, what's inherent in my Lord's question is, can you only have informed consent if the information comes from the fiduciary rather than from a third party?
My primary case would be no, but I say in the alternative, as you know, on ground 2, in any event.
So your answer is no. You can have informed consent if the information comes from a third party?
I would. Can I? I want to reflect on that precise question over the short adjournment, if I may.
Yes.
Can we go back one stage as well? Because what I understood from the discussion between you and my lord was that at the earlier stage, we weren't talking actually about the quality of the informed consent or where the information had come from. You were looking at the earlier prior situation, and you're saying that there is an express duty as a facet of those duties which we are very aware of, loyalty, not placing oneself in a position of conflict. There is an express duty of making clear all material factors. That becomes a separate duty in itself, and that's separate from informed consent altogether. So even if, and I'm not sure whether this was what my lord was meaning, but even if there were informed consent in the informed consent sense, which you would say is further down the road at the next step, you still have to have, and this was the question as I understood the way it was put, that you still have to have that upfront information from the fiduciary in order that there is not a breach. I'm sure that's what everybody understood, and I'm repeating everything.
No, my lady, I'm grateful. As always, the court expresses it better than I can. But my lord, my lady, I'm sorry. Yes, that's how we would put it under ground one.
And so you would say under ground one, even if there was informed consent, even, and let's not get into the difficulties of how you know as the client about the information. If that information has not been provided at the earlier stage, there is already, in any event, a breach of duty which cannot be made good. Would you say that?
I think that's probably right.
And cannot be made good then by the fact that the client knows.
I think we would respectfully adopt that formulation. Now, but practicalities are not to be overlooked in this context, because, and as we'll see indeed in this case, the reason why it's so important for it to come from the fiduciary is so that it is accurate and full. Otherwise, we do risk ending up in a, if I may put it colloquially, a twilight zone.
Well, that simply begs the question as to whether the consent is sufficiently informed. But if it is, take an example in which what is material to conflict is the fact that the fiduciary is a director of a particular company that's going to be involved in the transaction. And the fact that he's a director is available as a matter of public record from the accounts or some other register or publication. And the fiduciary makes no disclosure, but the principal does in fact go and consult the public register and discovers that he is a director and is therefore fully informed of what is material to a potential conflict. And suppose that, as it happens, the principal becomes aware that that's what he's done. Is there still an obligation? The fiduciary becomes aware of what he's done. Is there still an obligation on the fiduciary to disclose?
Well, in that scenario, respectfully, my lord, I would submit that the important factual limb is the fiduciary becoming aware that the principal knows. Because in that situation, the court might well take the view, well, at that stage, you're relieved of your obligation to inform the principal, because you know that the principal knows the material fact which had hitherto gone undisclosed. Now,
so it's not necessarily a personal obligation to disclose. I mean, it's been put as such in your submission so far.
I see the force of my lord's example, but the difficulty again, and when the court's setting down these principles or exploring, and we haven't even started on the authorities. I want to show you the cases, yes, because at the moment I'm articulating these points effectively as advocate alone. But there's much support for this in the authorities, and in my submission, it's not a coincidence because of that practical factor, which I do ask the court to bear in mind, of the importance of there being clarity. Clarity on the part of the principal as to what they are being invited to go into. And I understand, my lord, that one can hypothesize scenarios where the principal has discovered everything perfectly accurately for themselves. I understand that. First of all, that's not this case. And second of all, that would be a rare case, I would submit. And so we mustn't, if I may put it this way, we should be very careful about the direction in which we set these principles. We should avoid doing so by reference to highly exceptional theoretical possible cases, and focus on the importance of the fiduciary in accordance with his or her duties, making full disclosure. Perhaps.
I think your answer would be the same, even in circumstances where something that the fiduciary has done has put the principal on inquiry. We know in general terms that's not sufficient, but where the principal has, where the fiduciary has put the principal on inquiry, and the principal has inquired and found out the full information, your answer is the same. There's a breach of the fiduciary duty. I think that follows from your submission.
I think that's probably right, Lord. And I want to reflect on the exchanges we've had this morning over lunch and no doubt overnight as well. But you'll see how we express it in the skeleton under ground one. I don't think anything I've said so far departs materially from the way we've expressed it in the skeleton, which is that there is, we say, a duty, which one derives from the duty of undivided loyalty, or possibly the conflict no profit duties, on the fiduciary to make that disclosure.
No, I understand, and all I'm doing is exploring what the consequences are, and you say that nothing surprising about the consequences because it's all about the fiduciary knowing where they are and what they've got to do.
And again, risk of creating a greater load on my own back. When one looks at the authorities like Rukadze, amongst others, they stress the consistent theme in the authorities going back many years is the strictness of the obligation on the fiduciary. And it's in Rukadze they rejected the attempt to reverse the causation analysis on account of profits, but one sees it again and again. Perhaps we can look at some of the authorities so that, my lord, my lady, you don't have to just take it from me. Now, in the skeleton, and when I show you the authorities I'm about to show you, I'm going to stress two things. Or if I don't, I'm stressing it now, and hopefully it will emerge from the document. The first is the language of duty or obligation to make full disclosure. So again, don't take it from me, not that you would in any event, but you'll see it in the cases. And the second, so we've got language of obligation or duty, and the second is disclosure of all matters.
All material matters.
Sorry?
All material matters.
But all material, of course. So the disclosure has to be full, there has to be transparency. Now, in the skeleton, you'll have seen that we've quoted Bousted and Reynolds on this. For your reference, it's paragraph 50 of the skeleton. And in the skeleton, we have gone, earlier on, we've referred to the Australian cases. Now, I'm just going to show you two Australian cases. I will confine myself, unless the court tells me otherwise, to second appeals to the High Court of Australia. The first one is Authorities Volume 1, tab 3. This is the Daly case that we quote at paragraph 40 and 51 of our skeleton. Now, if I may, and again for concision, I will take you directly to the key passages upon which I rely. I appreciate that there may be other passages the court will consider in due course. So what we have in Daly is a claim for compensation by a client of a stockbroker who had placed money on deposit with the firm at its suggestion, and unbeknownst to the client, the broker was in a parlous financial position, became insolvent and was unable to repay the money. And there was a claim on a fidelity fund pursuant to certain statutory provisions. And the claimant sought to ground such a claim, amongst other things, on a contention the broker owed fiduciary duty. And we can pick this up if I use the pagination in the bottom right-hand corner, page 53. We are here in the judgment, so page 53, bottom right-hand corner, we're in the judgment of Chief Justice Gibbs. And he says, and I'm starting one paragraph down on the top. It was right to say that Patrick Partners owed a fiduciary duty to Dr. Daly and acted in breach of that duty. The firm which held itself out as an advisor on matters of investment undertook to advise Dr. Daly, and Dr. Daly relied on that. In those circumstances, the firm had a duty to disclose to Dr. Daly the information in its possession which would have revealed that the transaction was likely to be a most disadvantageous one from his point of view. And if we read on, normally the relation between a stockbroker and his client will be one of a fiduciary nature, and such as to place on the broker an obligation to make to the client a full and accurate disclosure of the broker's own interest. Now, that paragraph was quoted, I note.
Just before you go on, you're going on to another case, are you?
I'm going on to another passage in this case.
Oh, I see. Let's keep.
Now, we've noted in the skeleton that that page of the report, albeit without reference to the particular words I've emphasised, was referred to with approval by Mrs. Justice Popplewell in the FM Capital case, and that's see footnote 33 of our skeleton. As I say, she doesn't stress the words I have stressed. She refers to the paragraph of the report. If we turn forward, we will see the judgment of Mr. Justice Brennan, as he then was. And we can pick it up at page 60 in the bottom right-hand corner. I'm in the middle of the page, between the two hole punches. And it says, Dr. Daly sought advice from Patrick Partners on the investment of his money, and they advised him. The question is whether, in advising Dr. Daly, Patrick Partners were in a position of a fiduciary. And you'll see the quote then from Lord Chelfs of the Lord Chancellor. And if we turn the page, again in the middle of the page, the paragraph that starts, the duty of an investment advisor. His duty is to furnish the client with all the relevant knowledge which the advisor possesses, concealing nothing that might reasonably be regarded as relevant to making his investment decision, including the identity of the buyer or seller, to give the best advice which he could give. If he did, and I stress this bit, to give the best advice which the advisor could give, if he did not have, but a third party did have a financial interest. So that's the language of fiduciary obligations because of the conflict that existed in this case. To reveal fully the advisor's financial interest, and so on. And he says at the bottom of the page, Patrick Partners, in the paragraph at the bottom of the page, were therefore under a duty, before borrowing, to tell him fully and truthfully what they knew about their financial position, and to warn him give me just a moment. And I didn't light on this, but in that paragraph that starts the duty of an investment advisor on page 61, Mr. Justice Brennan refers to the duty being a heavy one. Now, in the skeleton, I'm sorry, it might not be.
So just keep going, and if you don't answer the point I have in mind, I'll come back.
Very well. In the skeleton, we've referred to the first instance New South Wales case of equitas. That's paragraph 41.
Well, actually, perhaps if you're going on to another case, let me just ask this. I mean, it's the Australians who traditionally have been very keen on the prescriptive distinction. Which you see, for example, in a case called Breen and Williams, don't you? But I can't remember the date of Breen and Williams. Expressed in the way in which you would suggest that we should read this looks like a prescriptive duty. How does that fit in with the Australian emphasis on proscriptive duties, not prescriptive duties?
Well, My Lord, you are taking me forward here, and so I'm grateful. What I was going to say is that we've quoted Equitas in our... I'm going to answer the question.
Yes.
I promise. We've quoted Equitas. I'm not proposing to spend much time on that case. There is a quote that supports our position. We've set it out in the skeleton. But I don't think we're going to get much assistance out of that case. It's a first instance decision, first of all, of the Court of New South Wales. At times it's not entirely easy to follow, because there's at one point there's a section on the content of the duty. There's also a separate section on the scope of the duty. The judge, when dealing with the content of the duty, seeks to reconcile Breen and Williams with Daly, and suggests that some of what Mr. Justice Brennan was saying there, in the passage I've just shown you, might be better understood as a contractual obligation. That can't be right, because of the references there in what Mr. Justice Brennan was saying to the third party, as if a third party was in it, not me.
But it could be shorthand for saying you can't put yourself in a position of conflict without proper consent, and this is what proper consent would involve.
Well, that's a different way. That may be, and I'm not trying to twist my Lord's word, that may be a different way of saying proper consent involves you telling the client. That's what proper consent requires. You've got to tell them. It can't be for them to go and work it out. And then we get into all sorts of practical problems. Now, no suggestion in any event in Equitas that what Chief Justice Gibbs has said is to be understood differently. And as I say, the language of Mr. Justice Brennan is clearly contemplating that issue of conflict. And that's what gives that language the fiduciary quality, because he's talking about as if you have no interest. If we turn up the next case I was going to show you, this is the only other Australian case I was going to show you. It is another second appeal to the High Court of Australia. And here we're going to see further language from now Chief Justice Brennan. And there's no departure in my submission. So the cases Maguire and Macaronis.
So just before we leave Daly, the conclusion in this case was that there was a breach of duty, but it didn't give rise to a trust. So it wasn't a breach of fiduciary duty so as to bring the claim within the scope of the fund. Is that right? I may have misunderstood it.
No, there was a breach of fiduciary duty, but I think I'll have to go back over it. But for reasons which I can't recall off the top of my head, but did read earlier this week, the provisions of the fund were not engaged. If I may...
But just looking at the head note, the finding seems to be that the monies deposited were not the subject of a constructive trust, which I would have thought would have been the consequence of the finding that there was a breach of fiduciary duty in relation to receipt of them by the firm.
And we see, I mean, the holding, my Lord's in the head note, I'll turn back to it myself at page 48. There has been a finding of a fiduciary relationship in the holding at 1.
Yes.
And a breach of it.
Well, in breach of duty, not disclosing its unsatisfactory financial position. I mean, the passage you showed us from Chief Justice Gibbs doesn't put the duty to disclose that the transaction was likely to be a most disadvantageous one as a fiduciary duty. He says the firm had a duty to disclose the information in its possession which would have revealed the transaction was likely to be a most disadvantageous one because it was the advisor on matters of investment. And one can quite see that would arise irrespective of any fiduciary. And then he goes on to identify the fiduciary duty as an obligation to make a full and accurate disclosure of the broker's own interest in the transaction. I understand you're pointing to this for the purposes of prescriptive duty, as it were, but I'm just slightly puzzled about whether this is actually a case which found a breach of fiduciary duty at all.
Well, my Lord...
It may have done. I'm not as familiar with it as you are. But.
No, it rather depends on how one reads those words of Chief Justice Gibbs at page 53 in that paragraph, where he starts by saying it was right to say that Patrick Partners owed the fiduciary duty to Dr. Daly and acted in enforce that duty, And then, as you say, there's the sentence about acting on investment advisor. And then he says, in those circumstances. Now, in my submission, that sentence, in those circumstances the firm had a duty to disclose, is referring to the fiduciary relationship. And if you can see that, my lord, I'm just engaging with the point my lord's floated with me there, that the next sentence says this. Normally, the relation between a stockbroker and his client will be one of a fiduciary nature, and such as to place on the broker an obligation to make the client a full and accurate disclosure. And so that sentence about the duty to disclose is bookended by sentences referring to the fiduciary.
Well, I understand that, but I started to read on a little bit. Not enough for the appellant to establish the relationship between Mr. Daly and the firm, for which the money paid was a fiduciary one. To bring the case within either section 97 or 58 is to show that the monies were received by the firm as trustee. And I think then the result of that analysis is the answer is no.
Not, yes, in this case, they took the view. I mean, this is maybe opening up a different debate.
Maybe, I just...
But they took the view, and you can see that in what follows, that it will not be the case that a person who stands in a fiduciary relation to another and has failed in his duty to make disclosure, that the money will be impressed with a constructive trust. They say that seems to me too sweeping an assumption. Now,
well, it may, as you say, it may be that we're going off on
Deep
a
water.
tangent to deep waters that don't matter too much. But I was just wondering, when we were trying to interpret what was being said, whether one needed to have an eye on what the result was as well.
I follow that, my lord. I put the case before you in relation to the question of whether there's an obligation to disclose arising out of the fiduciary's position when he's faced with a potential conflict of interest. I appreciate that there's an analysis here about whether then constructive trusts arise, which may not be entirely consistent with the approach.
To confuse matters, the Australian attitude towards constructive trusts is different to ours anyway.
Well, we then get into the debate about the cases in Canada as well, and remedial trusts and so on and so forth. And I'm certainly, to refer to my Lady Justice Applin's comments about deep waters, I'm certainly in waters deep enough for me at the moment.
Thank you.
So I was going to show you Maguire and Macaronis. I can deal with this, hopefully.
Which is where, sorry?
I'm sorry, tab 7 of the same bundle.
Thank you.
Again, I'll accelerate to the key passages from my perspective, if I may. It's a case involving solicitors. And if we pick it up, please. #145 in the bottom right-hand corner. So we've got solicitor and client, a settled category of fiduciary. I'm in the middle of the page. They distinguish prior cases, and they say the present case stands apart from those just mentioned because it involves a fiduciary relationship in a well-recognised category and a claim to a well-established remedy. And then this. And this is the judgment of the court, of which Chief Justice Brennan, as he now was, formed part. Nevertheless, even here, to say that the appellant stood as fiduciaries to the respondents calls for the ascertainment of the particular obligations owed to the respondents and consideration of what acts and omissions amounted to failure to discharge those obligations. You can then see what the appellants were retained to do in the next paragraph. And then in Clark, Boyce and Moat, which is a case that you'll see referred to in a number of the authorities we're likely to traverse in this appeal, the Privy Council referred to the judgment of Lord St Leonard's, Lord Chancellor, and Lewis and Hillman. And you'll see this. The classic case of the fiduciary duty arising is where a solicitor acts for a client in a matter in which he has a personal interest. In such a case, there is an obligation on the solicitor to disclose his interest, and if he fails to do so, the transaction may be set aside. And if we read on, equity intervenes, and this is, one might have read these words in ricade. Equity intervenes, particularly where the fiduciary is listed. Now I say it's with any fiduciary. There's nothing to distinguish different fiduciaries. They're fiduciaries. Not so much to reoccur loss suffered by the plaintiff as to hold the fiduciary to and vindicate the high duty owed by the plaintiff. And then there's a reference to CIBC and Pitt. Lord Brown Wilkinson referred to the considerations of general public policy, which found that he identified the long-standing principle whereby those in a fiduciary position who enter into transactions with those to whom they owe fiduciary duties labour under a heavy duty to show the righteousness of the transactions. Now, and if we turn the page, I'll just show you the passages relied upon by the respondents in this case, just while we're looking at the case together. 147. It's at the bottom of the page, you'll see it's sidelined. If the appellants are to escape the stigma of an adverse finding, it was for them to show by way of defence informed consent. What is required for a fully informed consent is a question of fact. Circumstances of the case may include the importance of obtaining independent legal advice. And then this, it should be noted, I'm sorry, I've turned the page, at the top of 148. However, it should be noted, and so this is relied upon by the respondent, that contrary to what appeared to be suggested by the respondent's argument, there was no duty as such on the appellants to obtain an informed consent. Now, and you'll see the final sentence. Now, the submission I make about that is you can't, as a fiduciary, one has to be careful about what the duty is. You can't have a duty to obtain an informed consent because that is not in your gift. I cannot have a duty to obtain an informed consent. That is not in the fiduciary's gift. What is in the fiduciary's gift is full disclosure.
Well, it goes on to say, doesn't it, the last sentence there, rather the existence of an informed consent would have gone to negate what otherwise was a breach of duty.
Yes, absolutely, my lady. But just pausing on the language of what the duty is, I think you have my submission on that point. May I just show you briefly next in the chronology?
Just before you do, I see, for example, at footnote 52, there's reference to Breen and Williams, which must have been decided more or less at the same time, which obviously is hot on the prescriptive-proscriptive distinction.
Yes, my lord. But it doesn't, one sees the judgment of this court, including, as I say, Chief Justice Brennan, maintaining a position in the passages I stressed.
And I don't remember, but I bet Chief Justice Brennan was in Breen and Williams.
I'll have to check that. We'll check that.
I think it was. That's what's then explained in Equitas, which is 2001. Breen and Williams 96, Daly 1986.
I follow.
But you'll see in Maguire that there remains an emphasis on the obligation on the solicitor to disclose his interest, quoting the Privy Council and Clark, Boyce and Lower. So there's no derogation from that. Then Mothew, briefly, appreciate the court will be well familiar with this case, and I just wanted to show you. If we turn up, please, page 199 of the bundle.
Please, will you tell me what divider?
I'm sorry, divider 8. I'm still in, at least in original form, bundle 1, but it may not be.
Yeah, but mine is all separated out because they broke. Okay, I'm with you.
I'm just going to show you what Lord Justice Millett said immediately after the passage quoted by the judge in this case. Page 199 of the authority. And at the top of the page we have the paragraph that we've already seen in the judgment. And immediately afterwards, by the first whole point, we see this. In this survey, I have left out of account the situation where the fiduciary deals with his principal. In such a case, he must prove affirmatively that the transaction is fair, and that in the course of the negotiations, he made full disclosure of all facts material to the transaction.
He's got in mind the self-dealing and fair dealing rules, hasn't he?
Yes, that's right. And he says, if one reads on, the rule is the same whether the fiduciary is acting on his own behalf or on behalf of another. So here, obviously, XY is introducing the appellants to a fund in which Mr. Megani is interested, and these principles are engaged. Full disclosure, he must and I would add, in terms of what is informed consent, when one reads up, and one was talking about his own benefit or the benefit of a third person. And this is more of a practical point, but I'll just make it while we're here. In my submission, that requires, whether it's interpreted through the language of duty or through the prism of informed consent, you can't disclose some of the third parties. You have to disclose all of them. And here there was reference to the GP, but there wasn't reference to Twinkle, or indeed the other entities that were introduced later.
Can I just focus for a moment on the classic statement from Lord Justice Millett? The fiduciary must act in good faith. He must not make a profit out of his trust. So, how do you understand that in the context of consent? Is that a freestanding rule, or is it to be read as he must not make a profit out of his trust without consent?
Well, looking at this, it's interesting because the language of informed consent is added only at the end.
So a solicitor's a fiduciary. He gets paid. He necessarily offends the rule that he mustn't make a profit out of the trust?
I'm sorry, my lord, we don't mean to focus on the facts of the example, but we're talking about payment not by way of fees by the client.
No, I'm talking about this is the fiduciary, a solicitor, ex hypothesi, making a profit out of his relationship by charging fees. And that's fine because it's all consented to. So where does that fit in on your reading of what Lord Millett has said?
Well, I would suggest that where you're dealing with the principle, which is that hypothesis, one mustn't forget the language that follows immediately afterwards.
Meaning that it's all qualified by without the informed consent.
If you're dealing with your principle, or on your own behalf or on behalf of another, which is obviously this case, then that language is engaged.
So just to be clear, do I read this as he must not make a profit out of his trust without the informed consent of his principal? He must not place himself in a position where his duty and his interest may conflict without the informed consent of his principal.
Well, I'm approaching it from a slightly different perspective here, which is that where you do have when in a sense rewriting those paragraphs, the answer is supplied in my submission in the very next paragraph of the judgment. So one doesn't need to ask a question because Lord Justice Millett has supplied the answer himself. And he said, where you deal, whether on your own behalf or on behalf of another, then these are the obligations that you come under. Full disclosure of all facts material to the transaction.
I can't remember what the remedies for the breach of the fair dealing rule are. Anyway.
Now,
You
next,
certainly get rescission.
I'm sorry?
You certainly get rescission. I can't remember
Yes.
whether you get compensation for breach of the fair dealing rule.
Again, my lord, off the top of my head, I can't supply with a ready answer either, but again, we'll come back to it. My lords, my lady, next in the chronology we have the item software case. Now, I don't propose to go to it again for concision. You've got it at tab 14, and it's properly understood in my submission as a case where Lady Justice Arden recognised the significance of the fundamental duty of undivided loyalty and concluded in that case, consistent, I would respectfully suggest, with the submissions I made, that in that case the company director could not fulfil his duty of loyalty except by disclosing his misconduct to the company. And that was paragraph 44 of the decision. And she also considered that there were powerful policy reasons that supported the duty to disclose. And just as in this case, she said it's not an independent duty to disclose. It arises out of, or as a facet of, the duty of undivided loyalty. And the disclosure required was there, consistent with the Supreme Court's recent observations in Ricadze, stressing the importance of invigilating strictly the role of the fiduciary and commenting in Ricadze on the continued existence of human frailty and temptation. So, Fasihi, or item software, is an example of the duty of undivided loyalty giving rise to the duty to disclose in circumstances where a conflict is on the horizon. Now, in that case, the conflict was effectively in the rear-view mirror. But there's no reason why the same principle, it was a historical, there's no reason why the same principle would not apply to a forward-looking situation where a conflict or potential conflict has arisen. Now, can I next turn?
Are you leaving item?
I'm sorry?
Are you leaving that case?
I was going to.
My recollection is that I've thought before that it's not about no conflict rule, it's about the duty to act in the best interests of the principal.
Yes.
And in fact, that seems to be paragraph 41 of what Lady Justice Arden said.
She refers, I think, to the duty on the director to act in good faith in what he considers, or she considers, to be the best interest of the company. She refers to that as the time-honoured rule, and that's 41. But at the same time, in the very next paragraph, effectively it's described as corporate laws. I won't try and paraphrase. She refers to the article of Professor Robert C. Clarke, who describes the fundamental nature of the duty of loyalty in particular terms in the corporate context. And at 43, Lady Justice Arden said, although Professor Clarke was writing about the duty of loyalty in the United States, his observations seem to me to express qualities of the duty of loyalty applying equally to the law of England and Wales. And at 44, she says on page 422 of Bundle 1, tab 14, the only reason that I can see that it could be said that a duty of loyalty does not require a fiduciary to disclose his own misconduct is that it has never been applied to this situation before. As I have explained, that is not a good objection to the application of the fiduciary principle.
And then you see why. She says, on the facts of this case, there is no basis on which Mr. Fasihi could reasonably have come to the conclusion that it wasn't in the interests of the company to know of the breach. So that's saying, in applying the principle that a director has to act in what he considers to be the best interest of the company, where that's the only reasonable conclusion, that's what I'm going to think he thought, and therefore he's in breach of it. And that's different, isn't it?
Well, if I may respectfully put it this way, she appears to see that formulation as part of the duty of loyalty.
Well,
rather than as a sort of separate concept.
I mean, Lord Millett has said you've got the idea of loyalty, and that has several facets, of which the first is the duty of good faith, which might be expressed as the duty to act in the best interest of your principal.
Well, I hesitate to suggest, and I say this diffidently, that outside of the strict corporate context with the predecessor, effectively the common law predecessor to Section 172, the result would have been the same because of the duty of undivided loyalty, which the judge expressly referred to. I understand my Lord's point that one way of analysing the case is to anchor back the references to what's in the best interest of the company, considered in good faith to be in the best interest of the company.
And that's not something that came with the Companies Act. It long predates the Companies Act.
Yeah, I appreciate that, my Lord. But actually, when I would respectfully submit that when one stands back and looks at the case, what's really driving the decision is the duty of loyalty. And in Saxon Woods, maybe we'll come to this after lunch, in Saxon Woods, one sees that the Supreme Court says we mustn't get caught up on what he or she considered to be in the best interests and the language of what appears to be subjectivity, my Lord, referring here to my Lord Justice New's decision in first instance in Maru, which the court was kind enough to draw to our attention early this week, and where what one doesn't know, but which passages my Lord had in mind, but it may well have been those passages where my Lord considered item software and suggested that the obligation should be considered with a degree of subjectivity because of the language of what one considers to be in the best interest of the company. And in fact, what we see in Saxon Woods is the Supreme Court says no. Duty of undivided loyalty, and it brings Section 172 and its analysis back into.
I mean, I haven't read Saxon Woods properly. I would be astonished if that dispensed entirely with Regent Crest, and the idea that you have to act in what you think are the company's interests.
Well, maybe.
But we'll see.
We'll look at it in a moment. Right now, I have got more cases to show you. I'm hoping that this is useful.
Yes.
And I'm conscious of the time. Now I've got more to deal with. We do have 2.5 days. I'll be much quicker on 3 and 4, but I would like to be able to address you on these cases, and hopefully, and I'm not saying to take any of my learned friends' time at all, but hopefully the fact that I've covered some of the facts and at least the first view at some of the authorities will make things easier as we move forward.
Yeah. 2 o'clock then.
Please, may I just say, I have, as I say, to divide a 48. I wonder if somebody could help me with the remainder of my authorities.
We'll supply you with a file. I'll say this and I'll be given daggers when I leave court, but we'll supply my lady with a file that contains the missing authorities, and we'll also address the missing cases from other members of the Constitution.
I'm very grateful. Thank you.